Hello, everyone, and welcome to Uncivil Law. For today's case, we have Steve Jackson Games versus the United States Secret Service. Steve Jackson Games was producing games, and the Secret Service decided to raid them during an investigation related to some information relating to the 911 system, but they kind of got the wrong guy. And they violated some laws along the way. So the Secret Service is getting a little bit of a smackdown from the court in the way they handle this. This is from Texas in the Austin Division. So let's read this case from 1993 and see what happens. In October of 1988, Henry Kerfile, director of network security technology, an affiliate of the Bell Company, was advised a sensitive proprietary computer document of Bell South relating to Bell's 911 system had been made available to the public on a computer bulletin board in Illinois. So some sensitive information relating to how the 911 system is set up, potentially creating some vulnerabilities. So they are making people aware of that. The information was discovered, among other places, on a bulletin board called Illuminati Bulletin Board, because of course it was. Now, how does Steve Jackson get implicated in this? Well, here's how. The only information that Agent Foley had of the Secret Service regarding Steve Jackson's games and Steve Jackson's was that he thought this was a company that put out games. But he also reviewed a printout of this Illuminati bulletin board on February the 25th, 1990, which read, "Greetings, mortal. You have entered the secret computer system of the Illuminati, the online home of the world's oldest and largest secret conspiracy. Many X's followed by 1200/2400 baud, which tells you exactly how old this is. 1200 or 2400 baud. If you don't know what that is, don't worry about it. It's long, long ago in the far, far away where computer speeds were very, very slow. Fronted by Steve Jackson Games Incorporated, FNORD. So this little message on this Illuminati bulletin board said that they had some sort of relationship to Steve Jackson Games. So this 911 information was on this board, among other places, and this said we have some association with Steve Jackson Games. So that would be enough to maybe look into it a little bit more. But what the Secret Service did was basically just seize all his stuff with a search warrant without actually doing any investigation or following any laws as it regards to this. And so there were some problems along the way. Did the Secret Service have enough to look into it a little bit more? Yes. Did they have enough to get a search warrant, seize the stuff? Well, not really so much. So let's read a little bit more. The evidence in this case strongly suggests that Agent Foley, without further investigation, misconstrued this information to believe the Illuminati bulletin board was similar in purpose to the Blankenship Phoenix bulletin board, which had provided information to and was used by hackers. Agent Foley believed in good faith at the time of the execution of his affidavit there was probable cause to believe Blankenship had the 911 Bell South document and related information to decryption scheme stored in a computer at his home, or perhaps in computers, disks, or Illuminati bulletin board at his places of employment at Steve Jackson Games. So yeah, this guy has some documentation. He has some affiliation with various bulletin boards and whatever, and so we think that this information may be in a whole bunch of places. We could investigate. We decided not to do that. Problems ensued. So, what are the legal interests here in when we're seizing information from these varying computing systems? We have a guy who works for Steve Jackson Games. He has some affiliations in one way or another with various bulletin boards and things. The bulletin board seems to suggest that there's an affiliation with Steve Jackson Games. So, we're not quite sure where this information resides. But what we're going to do is go into Steve Jackson Games and take his computer and his floppy disks and his brand new game that's yet to be released and seize all this information, creating a competitive disadvantage without really investigating it. So that was the problem. We got a search warrant based on this, and we just seized a whole bunch of stuff, and we didn't follow the law. So what laws did we not follow? Well, let's read on. The United States Secret Service, by Agent Foley and the Assistant United States Attorney Cox, sought and obtained an order from a United States magistrate judge to search and seize and thereafter read information contained in computing software and written material and documents relating to a computing system, documentation relating to the attacks of computers, and advertising the results of the computer attacks and financial documents and licensing relative to computer programs and equipment at businesses known as Steve Jackson Games, which constitutes evidence, instrumentalities, and fruits of federal crimes, including stolen property and transportation of computer access information. So we got a very broad search warrant that allows us to seize all the stuff as it relates to this ongoing crime. Okay. The evidence establishes that the actual information seized, including both primary source and backup materials of the draft of GURPS Cyberpunk, a book intended for immediate publication within days to weeks, drafts of magazines and magazine articles to be published, business records of Steve Jackson Games Incorporated, including contracts and drafts of articles, the Illuminati Bulletin Board and its contents, including public announcements, published newsletter articles submitted for the public to review, public comment on those articles, and electronic mail containing both private and public communications. Yeah, you have to remember, and this is long, long ago, before email as you know it really existed. This is old school bulletin board email when we used to have FidoNet accounts and stuff like that. Again, if you don't know what I'm talking about, don't worry about it. But yeah, this is some old school pre-email that existed on these servers. Yes, we're seizing all that stuff. Notwithstanding over 300 floppy disks being seized, which again tells you how long ago it was, the evidence introduced during the trial was not clear as to what additional information was seized during the search warrant execution. However, the evidence is clear that on March 1st, 1990, work product materials, as defined by law, were obtained, as well as materials containing documentary materials in the same provision. The Privacy Protection Act dictates, among other things, notwithstanding any other law, so no matter what other law says, this governs. It shall be unlawful for a government employee, officer, or employee in connection with an investigation of a criminal offense to search for or seize any work product materials possessed by a person reasonably believed to have a person disseminate to the public, a newspaper, broadcast, or other similar form of public communication. So basically what that says is when we're doing this, when we're doing seizure, we can't seize things that are to be published. We can't seize instrumentalities relating to things to be communicated. So articles, emails, that kind of stuff. We can't seize that stuff just for the heck of it. So we can't take that away because obvious First Amendment interests might apply. Assuming Agent Foley was knowledgeable of the Privacy Protection Act, which he was not, neither was he nor Assistant U.S. Attorney Cox had any information which lead them to believe that Steve Jackson Games Incorporated published books and materials and had a purpose to disseminate to the public its publications. Their testimony is simply they thought it as a producer of games. So they're saying, well, we didn't know as a matter of fact that it was. We just thought they were a game provider. We didn't know anything about their articles or their emails or any of that stuff. We just thought of them as a game producer, which would be legally different. But it doesn't matter. As herefore stated, the court feels Agent Foley failed to make a reasonable investigation of the Games Incorporated when it became apparent his intention was to take substantial properties belonging to the corporation, the removal of which could have substantial effect on the continuation of the business. So our problem here is that we didn't do our due diligence. If you had truly made an innocent mistake, that'd be one thing, but you didn't do your due diligence. You didn't look into it. You just made some assumptions. You didn't actually investigate, and you seized a whole bunch of things in violations of law, without cause. If you had done an investigation and you didn't find this information, then maybe we'll cut you some slack. But you didn't do that. You just kind of did it by the seat of your pants for some reason, and you violated some provisions of law that are now going to come back to bite you. Agent Foley, it appears, in his zeal to obtain information for his criminal investigation, simply concluded that Steve Jackson Games Incorporated was somehow involved in Blankenship's alleged activities because of a wording on the menu. So our tie here is a little thin. Blankenship works for Steve Jackson. And because of this random wording on this menu, we think that Steve Jackson is involved, which isn't necessarily the worst idea. But, you might want to investigate it. You might not want to go immediately to search warrant and seize all the things. A little premature on that one. During the search on March the 1st and March the 2nd of 1990, the Secret Service was specifically advised of the fact that it put its employees on notice of probable violations of the act. It is no excuse that Agent Foley and Golden were not knowledgeable of the law, because mistake of law is not an issue. It's not relevant, right? It's clear the Secret Service continued seizing the property of Steve Jackson Games Incorporated, including information and document, through late June of 1990. So we're doing this for a little bit. Immediate arrangements could and should have been made on March the 2nd, whereby copies of all information seized could have been made. So we could have given you back copies of the information so that you would have it. There's no reason for us. It's information. We could make duplicates. So we could give you back your information. We didn't do that. The government could and should have requested Steve Jackson as its chief operating officer to cooperate and provide the information available under law. So we could have gone and asked you to provide us stuff. We could have subpoenaed you. The Secret Service's refusal to return information and properly requested by Mr. Jackson and his lawyers in Dallas constitutes a violation of this law. So yeah, the government screwed up. They screwed up in the initial seizure, and they also screwed up in not giving it back, particularly because it's information, so you can just make duplicates. So yeah, we seized it, and we'll give you back copies of it. We could have done that, we didn't. And we didn't look into it, and we didn't investigate, and our excuses, well, we didn't know the law, though. No, that's not going to cover you. Mistake of law doesn't work for the government either. So, you can't do that. You should have looked into this and investigated. You didn't. Based on your knowledge about Blankenship, which seemed reasonable, you then took a notice of this thing, which said something about Steve Jackson Games, which probably gave you a lead. But what you did was go in there, seize the computers, 300 floppy disks, games, manuals, articles, and all the rest of it, and then refuse to give the information back so that they could continue in their business operations. And so you violated the law. You can't do that. So that's a bad thing. The plaintiffs allege that United States Secret Service's conduct also violated a different law as it constituted intentional interceptions of electronic communications. They allege the interception occurred at the time of seizure or perhaps at the time of review of the communication. There's no question that the individual plaintiffs have private communication stored in the Illuminati forum at the time of the seizure, and the court found from a preponderance of evidence the Secret Service intended to not only seize and read these communications, but in fact did read the communications, thereafter deleted or destroyed some of the communications, either intentionally or accidentally, which is just a basic no-no. You can't destroy things. That's destruction of evidence, incidentally. And it's also their property. So you can't just destroy things. You can't do that. That's a no-no. You can't do that. The defendants contend there's no violation of the particular statute under this facts because there's never any unlawful interception within the meaning of the statute. Alternatively, defendants contend that good faith reliance on the search warrant is a complete defense under the law. So they say two things. They say, well, we didn't intercept it, which is a technical legal question. Did they or didn't they? And they also say we have good faith reliance on the search warrant. Now, the problem with the second argument is that they were the ones who created the search warrant, right? If it had been a different police office that did it, that would have been okay. But it appears to be the same office who did it. And so that's not going to work because you didn't give all the information. So you can't good faith rely on a search warrant based on your own mistaken affidavit. If someone else did it, maybe, but it was you. That's a problem. So I don't know that that's going to fly either. Prior to February the 28th, 1990, Agent Foley of perhaps the Detroit Police Department by way of Beverly Hills, but now of Secret Service. Hopefully these jokes are landing. Assistant United States Attorney Cox, who was on the show Friends, and the computer consultants working with them were cognizant of public computer bulletin boards and the use of electronic communications and email through them. Each of the persons involved in this investigation, including Axel Foley, had knowledge and opportunity to log the Illuminati bulletin board, review its menu and user lists, obtain passwords, and thereafter review all information made available to the public. In fact, Agent Foley, who is trying to figure out what's happening in Wonderworld, which actually explains a lot of things, because Wonderworld was engaging in counterfeiting. That was the premise of Beverly Hills Cop 3. So Agent Foley, that makes sense, yeah. He went on to the Secret Service from his illustrious career because he got the bug about counterfeiting from that investigation, and now is working for the Secret Service. And so Axel Foley over here is investigating counterfeiting now and computer fraud. And he's up to his old tricks. Unfortunately, it's not working for him. In fact, Agent Foley erroneously thought kerfuffle, great name, Klooferfil, is now kerfuffle for the rest of the stream. Is kerfuffle because I say it is. Agent Foley erroneously thought kerfuffle had done this when a printout of the Illuminati documents dated September the 25th, 1990 was received. When Foley applied for a search warrant on February the 28th, 1990, he knew the Illuminati bulletin board provided services to the public whereby its users could store public and private electronic communications. When Foley admits to no knowledge of the Privacy Protection Act and provisions protecting publishers of information to the public, that is way too many P's. Wow. He testified he was knowledgeable regarding the Wire and Electronic Communication Interception Act, but Foley never thought of the law's applicability under the facts of this case. Good. Steve Jackson Games Incorporated, through its Illuminati bulletin board service, was a remote computing service within the definition of law, and therefore, the only procedure available to the Secret Service to obtain disclosure of the content was to comply with the statute, which it didn't do. As the search warrant application evinces, the Secret Service wants seizure of all the information and the authority to review and read all the communications, both public and private. That's a problem. A court order for such disclosure is only an issue if there's reason to believe the contents of an electronic communication are relevant to a legitimate inquiry. Axel Foley over here did not advise the United States magistrate judge, by affidavit or otherwise, that the Illuminati bulletin board contained private electronic communications between users or how disclosure of those content could relate to his investigation. See, this again is why you cannot rely on the search warrant. You withheld certain information from the magistrate. The magistrate granted the search warrant based on what you told them. If you withhold information from the search warrant, that's on you. So if it were another police officer somewhere who did it, then maybe you can rely on the search warrant that someone else did, because you don't know about it, right? So someone else lies to the police, you don't know about it, you can rely on the warrant on its own terms. But you were the one who generated the warrant. So that's why it's not going to fly. If you don't tell the magistrate judge certain things that matter, that's on you. So you didn't, for example, tell them about these communications and things, and didn't give them, the magistrate judge, an opportunity to note the provisions of this act. Not sure the magistrate judge would have caught on it, but you didn't even give them a chance. So you can't rely on the search warrant because you didn't tell them what they need to know. If you told them what they need to know and they came to the wrong conclusion, you could rely on that. But you withheld things, so you didn't even give them the chance. So not so good. The evidence establishes that plaintiffs were not able to ascertain the reasons for the seizure until the return of most of their property in June of 1990, and then only by efforts of offices of both United States senators of the state of Texas. So senators are getting involved. Please return their stuff. So they were out for 2 months. The procedures followed by the Secret Service in this case virtually eliminated the safeguards in the statute. So there's a statute here that deals with private communications because they're of third parties. Right, so there's information there, and there's rules. There's rules in these laws that you didn't follow, and that's bad. You can't do that. The complexity of this case results from the Secret Service's insufficient investigation and lack of knowledge of specific laws that could apply to their conduct on February 20th, 1990, and thereafter. It appears obvious neither the government employees nor the plaintiff or their lawyers contemplated the statute upon which this case was brought back in February, March, April, May, or June of 1990. But that does not provide assistance to the defense, because you have to know the law. Ignorance of the law is no excuse. The Secret Service and its personnel are entities that citizens, like the plaintiffs, rely upon to look to the protection of their rights and privacy. The Secret Service conduct results in a seizure of products, property, business records, business documents, and electronic communications of a corporation and for individual citizens that the statutes were intended to protect. It may well be, as the government defendants contend, these statutes relied upon the plaintiff should not apply to the facts of this case, as their holdings may result in government having great difficulties in obtaining information or computer documents relating to illegal activities. But this court cannot amend or rewrite the statutes involved. The Secret Service must go to Congress for relief. So yes, the government is saying, but as a matter of policy, this is bad. And the court is saying, look at my field. Look at my field. It is empty. It is fallow. I do not care. I don't do policy. I do law. Maybe the statute shouldn't apply to you, but it does, because it says so. I'm looking at it right here. I'm looking at it right here. It seems to be applicable to you too. So maybe it shouldn't, but talk to Congress. Let me know how it works out for you, but no, not so much for you right now. The plaintiffs are therefore ordered to submit application for attorney's fees and costs within 10 days of this order. So that is the end of the case of Steve Jackson Games versus United States Secret Service. In this case, the United States Secret Service came into information that one of the employees of Steve Jackson Games had some information that was secret relating to the 911 system of the Bell telephone system. And this information appeared to be distributed. They came into information this employee was affiliated with some message boards and bulletin boards, BBSs. We all remember those back in the day. And they also came into information that one of these bulletin boards, in passing, mentioned Steve Jackson Games. And on this basis, and no other basis alone, the Secret Service got a warrant, seized all the computers, the documents, the articles, 300 floppies, emails, and we're using the term email kind of loosely because we're back in the day email, where it's not email that you know and love. So this is old school email. But yeah, seized all that, and it was in violation of the law. It was in violation of the law because they didn't tell the magistrate about it, and so they're getting spanked. And so, yeah, the Steve Jackson Games successfully sued the United States Secret Service. They get their money back for this, and they get their fees back because you're not allowed to do that. They have to follow the law too. So that is the end of this case.